Welcome back. If you're just joining us, this is Good Morning Kenya. My name is Mike Migu. Now we talk about matters to do with land sector within the country. You know, land is a very emotive issue, and for a long time it has been facing different challenges. We are talking about matters to do with historical injustices, matters to do with inheritance, matters to do with ownership, and all these are engaged in legal tussles that sometimes take a long time to solve, which is why now we're looking at alternative dispute resolution mechanism, that is mediation and arbitration. Today we are looking at the role of mediation and arbitration in Kenya's land sector. And in this conversation, I'm joined by Eric Nyandimo, who is the President, Institute of Surveyors of Kenya. Welcome to the program.
Thank you.
Karibu tena.
Asante sana.
Umekuwa salama?
Yeah, niko salama.
Yes.
Yeah.
Now, let's get right into it. Now, if you're looking at mediation and arbitration in matters to do with land, maybe to set a context,
yes,
we start with the nature of land disputes within the country.
Okay.
Yes.
So we have a range of land disputes in the country, and these disputes could be on boundary, boundary conflicts, maybe due to encroachment from one landowner to the other.
Yes.
There could also be issues related to succession, where families are not able to agree on the division of the property in question. There could be disputed ownership, where somebody has settled on a piece of land, and then somebody is claiming ownership to that particular piece of land. There could be disputes in terms of the value of the land. There could be disputes on the use of the land use conflicts, especially where you have maybe pastoralists and you have people who are doing cultivated agriculture. And then you also have issues about absentee landlords, like we see mostly in the coast, where you have a widespread issue in terms of absentee landlords. Yes.
Now, you've mentioned succession, and it is one of the things maybe that plague matters to do with land, especially when it comes to inheritance. How prevalent is this within the country?
I would say it's quite prevalent at the moment, because people are starting to understand the need to have ownership documents, that is title documents, so that they can be able to use it as collateral, maybe to improve their lives. So in that context, you find that families, even when they have settled over a long period on a piece of land, then start having conflicts with regard to the documents and whose name needs to be on that particular document. So it's quite widespread.
Yes.
And it's something that, of course, needs to be handled in a good manner to ensure that we can be able to reduce on the conflicts like we see mostly, say, like in the western part of the country, Western Kenya, where you have smaller parcel sizes and you have larger families. So, yeah, there's increasingly disputes on that.
Now, let's look at both mediation and arbitration. Maybe before you even continue, what is the difference between the two?
So, mediation and arbitration, the difference is that in the context of mediation, you have parties that are in conflict working through a professional and getting to a solution. They arrive at a solution themselves. In the case of arbitration, the parties that are in conflict present their cases or their versions of the dispute, and then you have a third party who then determines the solution. So it's more of like a court process, but a less formal process. But the third party is determining the issue. But in the case of mediation, the two parties work together and arrive at a solution. Yes.
Now, looking at the role now, what role have they played so far in cases where matters to do with land are involved?
Well, we see more of mediation in land disputes. Arbitration is more when you have contractual obligations you have entered into a contract and one of the parties has gone against the contract, and you had it within your contract that when you have a dispute, then you would refer that matter to an arbitrator to be able to resolve the issue. So there's more of mediation in land disputes, and we are encouraging more of mediation in land disputes.
Yes. Where is ISK coming in all this now?
So within ISK, we have professionals who are involved on a day-to-day basis on land issues. That is from doing valuation to doing surveying to doing mapping to property management and so on and so forth. And since these professionals, the first people to be involved when there is a dispute, it is incumbent on us as an institution to be able to train them and improve their capacities when it comes to issues related to mediation. So as an institution, we have gotten into a memorandum of understanding with the Mediation Training Institute, and we are continuously training our members, empowering them on matters mediation so that they can be able to offer that as a service to the members of the public, and to also be able to educate and increase their capacities in that area. Yes.
You know, mediation and arbitration have been recognized by the Community Lands Act of 2016. But then the question comes, do they point to an inadequacy within the litigation process, or this is just a way to augment the processes that are happening at the court level?
They are really meant to augment what is happening within the litigation circles. So it's not really to replace, or not to say that there's a challenge or there's a difficulty with the litigation aspects. But even the courts have recognized the aspect of mediation. We now have what we call court annex mediation. So where an issue can be presented to a judge or a magistrate, and they can be able to order that the parties undertake mediation once the judge or the magistrate understands that maybe this is an issue that could be better solved through an aspect of mediation. So these are alternative dispute resolution mechanisms which can be reinforced to ensure that disputes do not take such a long time and do not cost quite huge amounts of money to be able to resolve. Because we have seen disputes that can run into tens of years. And frankly speaking, this doesn't give a very good picture. And there is need to ensure that disputes can actually be brought to a logical conclusion. So if mediation, arbitration can be able to support, then we support those particular processes.
In your own perspective, when it comes to the litigations that happen with matters to do with land, what do you think is the reason that most of the time they take too long to resolve?
One of the challenges is, of course, because you see, with the litigation process, you're looking at evidence which is brought before the court of law. And the judicial officer, the judge, magistrate, we need to be able to look at and understand all these particular issues. And sometimes you find that getting that evidence takes some time to be able to collect. Maybe because of the way the land records are kept, if they are not in a digital system, it becomes difficult to be able to trace them. And sometimes you're looking at trying to go to the root of the title. So you're going maybe 30, 40 years back to try and understand how maybe the land parcel came into being and where the conflict could have actually arisen from. And then, of course, there's also the aspect that once the court has ruled, somebody has the right to be able to appeal the decision that has been made. And based on the number of cases that are presented in court, it can take time, because there's really no limit that has been put forth to ensure that the cases are determined in a faster manner. Although I know that through the Chief Justice, through the Environment Land Court, they are now working towards ensuring that the cases can be resolved in a much faster fashion.
Yeah. So you think we may need a legal provision that gives a set timeline to deal with matters to do with land?
Especially on succession matters. Maybe other matters, the court processes can continue, but like we have seen succession matters that drag for even 40 years.
40 years?
Yes, and you have had different judges listening to such cases. And that is a lifetime.
Yeah.
And even keeping that kind of evidence and keeping track of what is happening through such a long period becomes a problem. We have seen in the issue of elections, when before, after having an election, a party would dispute a result and they would go to court, and the court would maybe take 5 years to be able to determine the case, the time by which the length of that parliament has already ended. So you even have a difficulty in enforcing that decision because the parliament is not, the parliament where that person wanted to be in is no longer in place.
Yeah.
So if we can work together with the various stakeholders and have a defined time period for these succession matters, maybe not more than 5 years, to ensure that all the arguments are brought to a logical conclusion and a decision is actually made, because a lot of resources are being spent on some of these cases.
Yes. Now, in terms of effectiveness of dealing with these matters, are the ADRs working? How effective are they?
I would say they are effective, especially when you look at the aspect of mediation, because where you have parties that are in conflict and they are able to arrive at a solution through the help of professionals, they are able to amicably agree on a solution, then that agreement, once the two parties have determined and there is no more dispute, then they can continue living as they were living before, or the whatever agreement they have come up to can then be enforced. Of course, there have been arguments in terms of how do you enforce agreements through mediation. So do we then enter that into a court of law, or? But of course, we also see that we have the aspect of the court annex mediation, where once the parties have agreed, then that agreement can then be recorded into a court of law and can be part of the judgment that would be passed by the judge or the magistrate. So I would say that the alternative dispute resolutions are working, and that is why they're getting embraced. And we have seen the judiciary has come up with the court annexed mediation rules from the year 2022. And we are seeing various professionals within the landed sector, the surveyors, the valuers, the planners, the architects, etc., taking ownership of this mediation process. Yes.
How does it work? How does the court annexed mediation work for a person who is hearing this for the first time?
So let's say a scenario where you have two parties and they're in dispute and they come before the court of law, and their cases are presented, of course, through their various advocates. And the judge, in his or her wisdom, can be able to make a direction that this is a matter that can be best resolved through the aspect of mediation. Yes.
Now, granted, the ADRs of mediation and arbitration, especially when it comes to land, how easy are they to initiate, and what could be the biggest challenges that may hinder the effectiveness of these ADRs?
I think one of the challenges maybe with the mediation is that you need somebody who is trained, so you technically need a professional.
Yes.
And in some cases we find that the professionals are more maybe in the urban areas or in the rural areas. There's also some cost element that is involved, because if a professional is putting time into the mediation efforts, then at the end of the day they need to be paid. And then if they're not in the rural areas and we have an issue in the rural areas, of course there's also the aspect of the travel time. And then there have also been those arguments in terms of how do you enforce those issues that are coming in from the mediation. But we live on the context that if this is a solution that has been arrived at by two parties that are in dispute, then the dispute would be sorted out by them coming to an agreement. Yes.
Now, you said you're involved in matters to do with mediation and arbitration as ISK, but then again, do you work with the National Land Commission in matters? How has that been?
We work very closely with the National Land Commission because many of the people also who are working within the National Land Commission are our members. So they're either surveyors, they're valuers, land administrators. So they're part and parcel of the Institution of Surveyors of Kenya. And ISK was in the forefront when the Constitution was being discussed to ensure that we have in place the National Land Commission. So we are a friend and a supporter to the National Land Commission, and we work with them very closely.
Yes.
And I think they have played a big role, especially when it comes to public land management on issues related to land allocation and so on and so forth. It's now a lot more organized. The process is fairly done in a lot more fair manner. Of course, working through the county governments or the national government, because those have to be supported by the National Land Commission. Yes.
Now, in the context of mediation, you know, there's the case of local elders and community leaders. What role do they play in all this?
In terms of if there's a dispute within that context, they would be useful because they can help the parties that are in dispute to arrive at a decision.
Yes.
Yes, by either looking at the history or giving relevant context to that particular matter. So if they're called in to be able to help the parties arrive at a decision, then that becomes a crucial thing. Of course, we need to do more in terms of educating them and building their capacity so that they can be able to support these efforts on alternative dispute resolution. Yes.
Now, you know, in matters to do with mediation, neutrality and fairness is paramount. So, are there safeguards that are there to ensure that these two aspects are well applied when it comes to mediation? Yes.
I would say that the aspect of neutrality would be more crucial when it comes to matters arbitration, because the person who is doing the arbitration would need to make a decision. In the case of mediation, the third party who is a mediator, their role is to help the parties arrive at a solution. The role of the mediator is not to make the decision. It is for the two parties or the three or the four parties to come to an agreement. And of course, in that aspect, in his or her dealings, they must try to be fair and to help out with the context to enable these parties to make a decision. Yes.
In matters of arbitration and mediation, arbitration, which is more legally binding? Is it arbitration or mediation, or both can be?
I think it depends on the context, but you find that in arbitration you already have a contract which specifies that if there's a dispute, then the first place that you need to go for is arbitration. So in that case, then it would be legally binding because you have put it down in a contract and you have actually signed. In the case of mediation, where you have the court annex mediation, of course, you can be able to enforce that kind of an agreement. But where you have a situation where there's no formal court process, then it's something that needs to be debated and a decision taken. Yes.
In terms of capacity, in matters to do with, especially when it comes to arbitration, do we have enough people who can undertake such cases if they arise and when parties decide this is going to be an out-of-court settlement? Yes.
I think we have a good number. Most of the people within the legal fraternity are also trained in arbitration, and they get to register as arbitrators, and they can be able to do that, of course, including other professionals. So I don't think we have gaps or capacity issues when it comes to issues of arbitration. It's more once you have trained and you get on board, you can be able to undertake that particular process. Yeah.
Anyone can train as an arbitrator?
Not necessarily, but we tend to see more of, say, the legal fraternity on the context of arbitration because of certain contexts. But you also have, depending on the kind of dispute that you can have, you could be an accountant and so on and so forth on those issues of arbitration. Yeah.
And what kind of land disputes would call for arbitration more rather than mediation?
Yeah, so in the context of where you have entered into a lease, where, for example, you are renting property for a number of years, and you've indicated within the contract that if there's an issue, then you resort to arbitration.
Yes.
So at least there needs to be some form of contract, and the parties should have signed on that. So you'd look at issues in terms of property management, aspects.
Right. Yes. All right, let's take a very short break. We continue with this conversation after this short break. Stay with us. Welcome back. We're looking at the role of mediation and arbitration in Kenya's land sector. Eric Nyandimo is the president of Institute of Surveyors of Kenya. And as we continue with this conversation, how can we ensure that people get more information when it comes to these matters, and how prevalent, especially when is the knowledge of alternative dispute resolution when it comes to land matters?
We still need to do a lot of education and campaigns so that we can be able to inform the population that there are alternative dispute resolution mechanisms. Of course, the first point of contact for most disputes would be to take the issues to court. And it's also good that the courts have also now adopted the mediation aspect. So there are certain issues that they can be able to refer to mediation so as to reduce also the number of cases that need to be determined. So the aspect of awareness creation, aspect of education, aspect of campaigns in the media, through barazas and so on and so forth would help quite a bit. There's also the aspect of training and capacity building for relevant professionals, especially those in the landed profession, from the university where they need to be trained to include matters of alternative dispute resolution as part of the curricula, so that by the time they come out, they're already aware that those are some of the opportunities that exist for them to use to resolve problems. Because typically when there is an issue on land, a surveyor will be approached, a valuer will be approached, a lawyer would be approached, and it would be important if they can be able to educate those who are approaching them that if there's a dispute, this is how we need to be able to go through this dispute so that we can resolve it.
Yes. As an Institute of Surveyors of Kenya, have you also tried to engage the private sector in matters to do with ADRs?
There's a lot of discussion on ADR through a number of initiatives like the Kenya Private Sector Alliance, KEPSA, and also through the Association of Professional Societies of East Africa. And as ISK, we are involved in both organizations or institutions. So I would say that we have been in the forefront, really, talking about matters, alternative dispute resolution. Yes.
You know, when it comes to land matters, it's not only about private land ownership, but also there's the aspect of community land. So how do you ensure that marginalized entities like women, the youth, are involved or are assisted to get a fair alternative dispute resolution process that involves mediation and arbitration in matters land?
The community land issues are quite relevant at the moment because with the enactment of the Community Land Act, the aspect of how you register the communities is coming a lot into play.
Yeah.
And whereas there have been some successes in a number of areas, they still need for effort to be done on these aspects. And we have a lot of non-governmental organizations that are involved on community issues, community interests, that are taking up campaigns on such issues involving the women and the youth. As a matter of fact, the Institution of Surveyors of Kenya is engaging with other stakeholders on a campaign which we call a Stand for Her Land campaign, which would be looking at empowering women rights and enhancing women access to land. We are still working out on the finer details, and we should be able to discuss that in good time once all the details are in place, to see that such issues can be brought forth. As an institution, we are primarily involved in undertaking land clinics, where we send professionals to different parts of the country, and they serve to talk about some of the issues that you've asked, in terms of bringing forth the youth, bringing forth the women, and talking about the community interests.
Yes. How effective have they been, these land clinics?
They are, in one way or another. Maybe there are an aspect of time, and because I've been involved in a number, and you have a lot of questions coming in from the members of the public. So it tells you that there are a lot of people who have a lot of issues and a lot of challenges when it comes to disputes. And maybe because of funding gaps, you're not able to spend as much time as you'd want to spend with them. But it is something that can be supported, and we are trying to see whether we can work closely with the county governments to support these processes, so that we can deploy our professionals in an area that they can be there for maybe even up to a week, rather than just spending one day. They can be there for even a week to discuss on those issues, and to see how we can help the communities get to a solution.
From these land clinics that have happened, what are the most pressing issues that are relating to land that you can point out that they are interlinking issues amongst the people?
A big issue is on succession, inheritance, and in certain cases you have disputes that where you have somebody saying that I've been living on this piece of land, and then recently somebody has come up and is saying that this land belongs to them and that I need to vacate, and all my life I've been living here. There are also issues in terms of maybe the way the plots were subdivided. Somebody was told that this is maybe 1.5 acres when it is really maybe 1.25 of an acre, and so on and so forth. So, or somebody has put in the boundary, planted the boundary, and the other person has removed the boundary. So these are the kind of issues that keep coming up.
Now, looking into the future of mediation and arbitration in the country, what do you think needs to be done to strengthen these alternative tools for solving land disputes? One
is on looking at the policy and the legal framework. Already, as we have said, the judiciary has been on the forefront to embrace mediation because they see its relevance and the fact that it can actually help them to mitigate on the cases that are brought before them. But we also have the aspect of the national land policy, where we need to really ingrain the aspect of mediation as one of the ways of resolving the disputes. At the moment, we are in the process of reviewing the land policy. It has taken a lot of time because the last policy was running from 2009 to 2019, and since 2019 up to now, about 6 years, we are yet to finalize on the land policy, but we are hoping that this is one of the areas that needs to be brought out to be streamlined. So looking at the policy, looking at the legal framework, looking at the institutional capacity, and essentially enhancing the roles of the land management boards. We have the land control boards, which are spread across the country, and whose capacities need to be enhanced, and so that they can be able to understand that these alternative dispute resolution mechanisms are some of the areas that they can use to resolve some of the conflicts that keep on arising with the cases that they deal with.
Now, we are living in the age of technological advancement and in what is called the digital age. So how can these digital platforms help in enhancing, say, the effectiveness of mediation when it comes to land disputes?
I would say one it may not be directly related, but there's one area, like we're talking about, there's a technology called remote sensing, where we take images of the Earth using satellites. And these satellites have been taking images, say, from 1972 up to now. And the resolutions of these satellite images have been increasing. I believe many of us are familiar with, say, Google Earth platforms, which is making use of archived satellite imagery. And this remote sensing technology has proved to be a very effective tool when it comes to looking at issues of adverse possession, especially where you say, where somebody or a group of people invade a piece of land, and then they start saying that they have been living in that piece of land for the last 20, 30, 40, 50 years. And if we use this technology, we are able to look through and see that piece of land over the years and can tell you with certainty the point when the people started living in that land. And we can then be able to help in mitigating cases of adverse possession, whether they have really been living there or it's something that they moved in the last 2 or 3 years, and therefore their claim for adverse possession then is invalidated by the fact that they have actually not been living there. And people are very crafty when it comes to issues related to adverse possession, including using old mabatis and things like that. Getting old people to move into the site to look like they have been living there for quite some time. So technology can really be able to unearth such kind of issues. Your final word. Just to indicate that as an institution, we are going strong and big on this issue of mediation. We are organizing a training for members in the month of August, and we are hoping to increase the numbers of our members who are trained as mediators and who can be able to offer this as a service to the members of the public. We have also planned an activity, the ISK Property Expo, which we are scheduled to hold on the 13th to the 14th of September at the KICC, where we will have developers and real estate practitioners coming on board to showcase some of the things that they have to the members of the public.
Yes.
Yeah.
Thank you so much for coming to talk about these matters, especially when we are talking about alternative dispute resolution in matters to do with land. That is Eric Nyandimo, who is the president of the Institute of Surveyors of Kenya, joining us here on Good Morning Kenya to talk about that. This is where we end this conversation and the entire Good Morning Kenya. Thank you for tuning in, and on behalf of my colleagues, that is Vivian and Victor, enjoy the rest of your viewing. My name is Mike Megwe.